The law is a scary thing, and I completely acknowledge that. However, it's not it's not capable. It's very easy to understand basic concepts, and I think if you drop the fear and look at what's going on and try and understand a bit better what's going on for yourself, it will actually improve a lot of the legal concerns and the worry that wakes people up at 5 in the morning.
Hi, and welcome to the Business Owners Forum. My name is Matt Murphy, and I'll be your host again today. We've had some great speakers over the last, pretty much 9 months of really bringing this to you. And it's been great to be able to connect, share, support, and strategize and implement some of the complexity of running businesses and really trying to make sure that we come through this, especially this period of COVID, and come out the other side from the thriving perspective. So, we've had some great topics covered and really great speakers over the period of time. And these are some of the topics we've covered across on. And so today, once again, we have got a great speaker. I'm really pleased to introduce Brendan Swift from Altus Lawyers. Brendan's been somebody that I've dealt with and has supported me and also our business over a number of years in regards to dealing with legal matters. And so I thought it'd be great for Brendan to share sort of his knowledge on, how business owners can think like lawyers and save time, cost, and stress associated with doing that. Because the law is an area that can keep us up at night time as business owners and navigate through the complexity of that. So I just thought it'd be a great topic to talk with Brendan on. So I'm going to say hi to Brendan, and I'll do a formal introduction just so make sure that everybody understands Brendan's background. But very experienced lawyer in Melbourne and runs his own legal firm. He's had a background in politics and been political advisor to 2 ministers in New South Wales. Has also been consultant to the Motor Traders Association and became a lawyer in 1996 and worked in a broad range of sort of legal areas. His firm, Altus Lawyers, works primarily in disputes, resolutions and litigation, and he's often called on to act for clients when other firms have conflict of interest and other lawyers feel out of their depth. So, he's had some recent matters, including acting for 2 separate CEOs in disputes, shareholder disputes, and an appointment by the Supreme Court of Victoria to assist in IPO wealth proceedings. So he's a big fan of technology, and I know that because I've been involved in some of the things that he's been up to. But welcome today, Brendan. Really pleased that you're able to join us and share your thoughts today.
Thanks, Matt. Good to see you. It's a sunny day outside, but we're both inside here.
Exactly right. So what I'd like you to sort of cover off today and share with us, I know that you've got, sort of your top 5, areas where, if you start to think like a lawyer, which is a bit of a scary concept to start thinking like a lawyer, it's like starting to think like an accountant like me. So, I know that scares a lot of people, but if we start to think more and put ourselves in the shoes of a lawyer, your experience is you find that you have a much better experience, it reduces stress, reduces costs from that point of view. Because there is my experience is with being in business and being a business owner like you are, is that there is a lot of stress that comes with it. A lot of times we wake up at 3 o'clock in the morning worrying about, legal matters that might be going on, circling around your business. So really like you to sort of cover off from that perspective as well, of how you reduce that fear or concern or stress associated when you're going through your top points. So love to sort of hear some of that insight. So I'll hand it over to you, Brendan, if you like.
All right. Well, thank you. Thanks, Matt. We have worked together over a number of years on different things, and often I think when a legal problem comes up, it feels like an alien has landed in front of you, because you don't know how big it is, you don't know if it's going to kill you, you don't know if it's going to leave peacefully. So it's quite the law is a scary thing, and I completely acknowledge that. However, it's not capable. It's very easy to understand basic concepts, and I think if you drop the fear and look at what's going on and try and understand a bit better what's going on for yourself, it will actually improve a lot of the legal concerns and the worry that wakes people up at 5 in the morning.
Mm.
So I've got 5 points that I think will help with this for business owners, and I'll just run through them one by one, and we'll start off with the one that I think is sort of fundamental, and that is that the first secret is that legal documents, they're not rocket science.
Mm-hmm.
Now, I think that if you look at a document, you can see, well, it's 100 pages of, very complex language. Now, that is true, and lawyers are very good at saying things in a far more complicated way than is necessary. But the basic concepts are not complicated. And if I use an example of your car, everyone can drive a car, everyone can operate a car, everyone knows what happens if you put the brakes on. There's a sense of predictability about it because you know how to use it. But if you were to ask someone, well, how does the brake work, or how does the engine start, they're going to have a lot of trouble because they don't know the technical detail.
Mm.
But you don't need the technical detail to understand the big picture of what's going on in a legal document. So if I just use as an example of this, one document which people shy away from, they can't bear thinking about, but it's a common example of a document. It's not necessarily a business document, it's an individual as well, and that is a home loan document.
Mm-hmm.
So on its face, 40 pages of terms, then you've got a document called a mortgage, and then you've got another document that's referred to called a Memorandum of Common Provisions, which is equally complex, and it sits in the Land Titles Office. So essentially, when the bank gives you your documents, you've got 100 pages of, I'll call it legalese for the moment. However, put the documents aside, the transaction itself is not actually that complicated.
Mm-hmm.
So what's happening is you're borrowing money from the bank and you're promising to pay it back. The bank promises to give you the money, and as security for the promise that you're making for the payment, they're taking a mortgage over real property, which is again a complicated word for essentially land.
Mm-hmm.
And if you don't keep your promise, then the bank can take and sell your property, or it can sue you for the debt, or both. Now, that's not actually that complicated.
No, it's not complicated at all, but there's 100 pages that says that it is.
That's right. But if you look at the 100 pages, you can divide the 100 pages up into the elements of it. So for example, there'll be something about the borrowing facility, and it will speak about how you access the money. Sometimes it's drawn down with a construction loan bit by bit. Sometimes it's available upfront. Like on the purchase of a house, the bank lends the money and the whole lot goes across. Then there are sections that deal with enforcement. So what happens if you don't do something?
Mm.
So like a car, I could take you, Matt, to a car and I could say, okay, what moves this thing forward? And you'd say, well, it's in there. It's under the hood. We'd say, okay, so we'll open up and there's the engine. So you can identify the bits of the transaction from the document. The headings are usually pretty good, and the headings will help you. So the first thing to do is don't worry about any of the words in the document. Just look at the document and see how it's made up, like you'd look at a car. There are the doors, there are the tires, there's the wheels, there's the engine. So if you do that, suddenly you can see, well, hold on, it's not just meaningless, it's organized in a logical fashion. And then when you start looking at it, bank documents do have a fair bit of plain English these days. And when you look at, for example, a clause that deals with enforcement, so it says, if you're in breach, these are the things we can do. They'll list them out.
Mm.
Now, as long as you can see and identify that and go, okay, so if I don't do this, then they can do something, that's probably the really significant thing to know.
Mm.
Now, I'll give you an example of something which sits deep down in the documents that no one really ever thinks about. And that is that once you take out a loan with a bank, you promise that you will not sell that property without their consent. Now, on a practical level, pretty much every person who ever sells a house goes into breach with the bank on that. What they do is they say, we want to move, they list their house with the agent sells it, a contract of sale is signed, and then they go to the bank and say, we're having settlement on this date. And the bank goes, fine, we'll turn up, you pay us the money you owe us, and we'll release the title. Now, the fact of it is, you can't do that legally. However, everyone does it. So within every contract, there are things that don't mean that much, and there are things that are serious. So like a teacher, if you make a bit of noise, that's a small problem. If you start to put a fire in the bin and assault people, that's another level. So every document has levels of problems.
Yeah.
So what I say to you, Matt, and to any listener is, if sit down, do it as an exercise one day. Grab a document you don't understand. Sit down, read it, look at the headings, then start reading through it and just mark off the things you don't get. Then what you do is, after you spend an hour or two doing that, because this will be useful for any document, apply a bit of brain, then get your lawyer and say, now listen, I want to understand this document. Take me through it. You explain what you know, and then you'll come to a bit and say, okay, I don't understand how, for example, if I go into breach, what happens then? Now, under a normal bank document, they give you notices, you've got 14 days to comply, and that's for the non-serious things, the making noise in class type things. If you burn the property down and don't pay your money at all for a year, then they're going to be able to do the worst thing and take and sell it. But it's all graduated. So if you call it an hour or two on a document, don't treat it like a Bible that someone else reads. Actually look at it yourself. You will pick up a whole lot more. I've got an example of this that happened one day, and that was a client who he had originally gone to a lawyer to get a document drafted, and it was an employment contract. And the employment contract provided for the employee to not use any of the information that he had obtained in the course of his employment with any other person. And that obviously applied to a new employer.
Which is pretty standard sort of wording in most employment documents. Absolutely
bog standard, you're dead right. But what you've got to do is actually look at your contract to make sure it's there. So he had this document originally drafted. He'd used it for maybe 15 or 20 people. And at some point during the 15 or 20 people, someone had amended it to suit a particular person.
Right.
And then it had changed again. So it was probably, 6 changes from the original one that the lawyer had done. Client had a staff member leave. Staff member goes to a competitor. There's deep concern because he's downloaded material before he's left. I get the document. What can we do? So I have a look at it. And Matt, what had actually happened was that the sentence should have said that the employee must not use or disclose the confidential information. But because of the editing that had occurred, it said he must use the confidential information. So in fact, instead of being prevented, he was compelled to use all the information with the new employer.
Yeah.
Now, the problem with that is that that's just one word. Had someone sat down and actually read it, instead of treating it like, this is the document we have to sign, excuse me, but say, what does it say? The word not wouldn't have been missed because it would make no sense. So it's worth knowing how your documents work, Matt, and it's not hard. It is not hard to do that.
And I think also the lesson on that one too is about the fact of having, standard templates that you actually amend, but always going back to the original sort of thing when you go to the next document. That's something that we often look at too from a engagement letter perspective, because you obviously, which is a legal contract binding between yourself and your client, and that gets changed all the time. Okay, and then people usually just grab that document and roll it over to the following year for that particular client, or use it for another client. And it might have been, as you say, tailored or amended, and loses that sort of the rigor of what the original document that you went to effort to get checked by a lawyer to make sure you're protected and the client's protected. So we talk about having version control in legal documents in our own organisation too, to ensure that because we've been tripped up on that in the past as well, where people have done that. Now we haven't had any adverse consequence associated with it. It was just something I picked up and made sure that we didn't continue to do that. So now we're very strong on version control, and we're actually got a piece of software that doesn't allow us to continue to roll documents forward if they've been amended or changed. So I think that's another tip out of this particular example that makes sense, not only knowing the wording, but also controlling the wording in documents when you're in business.
Well, that leads into my second point, second secret, if you want to call it that. And that is that if you learn to think like a lawyer, there are two massive benefits. Firstly, when you work with a lawyer, when you actually need the person, it's going to be more harmonious because you understand how they think. And secondly, you'll apply that thinking to dealing with business decisions as well. So let me give you an example of how you can better think like a lawyer. So as we go back to the example of the contract with the employee, which no doubt had the word "not" in it in the original version. If you agree something, then the normal way to record it is in a contract and you sign off on it. Now, what often happens is that people will they'll sign a contract, they'll treat it as if it's immutable, and they'll put it up on the back shelf, and then they will just go on with things differently to the contract. So they might, for example, vary the price of the product, and someone, instead of ordering under the contract, they'll order in a different way over the phone. They won't send a notice under the contract. They might vary it. They might have a dispute under the contract, but then they won't actually turn to the dispute resolution mechanisms in the contract. So essentially, instead of having the contract as a live document, they treat it as if it doesn't matter because it just has to be signed as a formality, and then you go on with ordinary business. Now, the problem with treating the contract separately to how you carry on in the future under the contract is that you may well have varied the contract from what appears on your shelf. And the moment that there's a problem, a lot of people do is they turn around and they grab the contract off the shelf and they go to their lawyer and they say, I've got this problem, look at the contract and tell me, are they doing the right thing? Now, the first thing the lawyer's going to say is aggravating to you. They're going to say, what about any emails that you've had between yourselves after the contract? And as soon as that happens, there's this sort of misunderstanding because the client thinks, well, we signed a contract, so why won't the lawyer just tell me what's in the contract? Whereas the lawyer's saying, I know you've signed a contract, in their head. I know you've signed a contract, but anything you've done since might vary that contract. So if you start to think like a lawyer and go, you know what, every time I'm talking to the other side or my supplier or whoever it is you've got the contract with, if you do it with a view to fitting it into the contract, then when there's a problem, first of all, you'll know your lawyer's going to ask you for that stuff, so you're ready for it. It's not a surprise. And secondly, you can actually think about whether or not in the course of communicating with people, you are changing it. Because it's the lack of clarity that comes out from the exchanges after the contract that is the prime source of disputes. What does that email mean? Has the price been varied for all products or just this particular one? Is the dispute resolved or is it not? So if you can think like a lawyer on the way through, you'll be able to understand, in fact, how you can change things by having these external contracts, external discussions.
That's an excellent point, and it's one that we really should sort of highlight and focus on and acknowledge a bit more, because that's where it's not the legal contracts that are going to get us into trouble or hot water or dispute. It's the stuff that fits in between, as you say. And in the natural course of a relationship, there's lots that go on between two parties that in good faith and goodwill and all that sort of stuff applies. And that, you know, sometimes by trying to do the right thing by your client or supporting them can actually cause you more harm than good. And this is the difficult part about it is that this sort of balance right between being, you know, too legalistic and structured to protect yourself and sort of building a great relationship with your client to ensure that you're not being difficult. So every time there's some slight change that you don't look like, you know, you've got to go back to contractual terms to deal with this. So we understand why people are doing it, but I suppose what's going to help you get there from what I'm hearing is that, yes, still be relationship orientated, but just make sure that you're not going to trip yourself over when it comes to if there is any dispute and it does fit inside your contract.
It's often a good idea after, say, 6 months of having a contract where there's been, you know, changes like I've described. You might want to just sit back and, you know, particularly if it's a high value contract, sit back, email your lawyer with, say, the 15 emails that have exchanged and say, listen, I've got this contract. Here are 15 things that we've done that I just wonder if it's affected the contract. Do you want to have a look? Now, usually at that sort of point in time, a lawyer's going to be able to say, well, actually, look, you've probably done this. So what we need to do is send an email back, say, listen, we're just going to clarify where we are contractually. That stays, that stays, that stays. We're actually changing that. We've agreed to change that. And then suddenly everything's clear again. And if you fall into dispute, it's not 3 years worth of emails. It's, well, we fixed that after the first 6 months, and that explains what happened. So so it's a good example. I've also got an actual example of how I guess thinking about your lawyer can help as well, Matt. And that was what I'd say to you is let the lawyer do their job, but try and help them get to do that job. And what I had was a client. He emailed me a document which was a loan document for his company, and he was a guarantor of that loan, and it was a pretty significant loan. And the company had gone into liquidation. So what he was afraid of, and very, you know, had good reason to be so afraid, was that the guarantee would be called on. So the business that made the money had collapsed, and he was going to be called on to honour the debt to the supplier. And he had other lawyers before, and I'd done one thing with him, and it was limited. And he said, okay, I know how you guys work. I want you just to look at the clause and tell me whether I'm liable. Just look at that one clause. And I said to him, well, that's a problem because a document is like a musical instrument. Things play on each other. So I'm not going to look at that clause. And I must look at the entire document. And he was grumpy, but he said, okay. So I looked at it. And then what I noticed was that the guarantee signature, I knew his signature from the previous transaction. The guarantee, his signature was different.
Right.
It was his name, but it looked different. So there was doubt about the clause about the guarantee itself. He had a valid question. But I went back to him and I said, now, I just want to talk to your PA. I spoke to his PA, and what we worked out was that he didn't actually put his signature on the document. It was someone in the organisation who did it because someone in the credit department of the other side said we need a signature saying his name. Now, as a result of that one thing, he didn't have any liability. Guarantees are read very strictly against the person who claims on them. So he hadn't actually signed the guarantee. So he actually escaped completely. Now, had I done what he'd said and only looked at the clause, he would have walked away with, oh, there's doubt about whether or not I'm liable. Whereas what he got, I just wrote a 6-line letter saying he didn't sign the guarantee. That was the end of it. He was not liable at all, completely. So the thing there is that lawyers are good at their jobs. Don't come in with your own set of views about what's important. Let them do their job and give them the freedom to look at it. And you will get a lot more joy from that. And particularly if you understand how they think, which I'm trying to convey here. And there's probably something you have not thought of. And in that case, it worked beautifully.
And that's been my experience with you, Brendan, over the years, is that you look beyond the obvious, you know, and you look to, you know, as you say, I think it's a good analogy to say that a legal document is a musical instrument, and it all sort of, or an orchestra, and it all sort of comes together based on all the different terms and clauses and attributes to it. And I think that you're right. You know, we often do think that we're bush lawyers sometimes, and come in with preconceived ideas about, you know, what the outcome's potentially going to be. And you know, my experience always with you is it's been great, because, you know, I've said, look, this is as much as I know, and then you've come in with a completely different angle or something, like, oh, that's cool. I like that. So yeah, I do really do concur with that. When you do have, if you're going to engage a lawyer, you trust them, because that's their area of expertise, and they do this all day, every day.
So thanks, Matt. The third secret that I have is that if you brief your lawyer in advance, you will get good value. And I'll just tell you how things sometimes happen for lawyers. Someone will have an immediate problem, and they'll ring up and say, look, I've only got, you know, 15 minutes. I'm going into a meeting in 15 minutes. What does this clause mean?
Yeah.
Now, going back to my orchestra example, a lawyer is not going to want to, over the phone, give you an answer on how one clause on its own might operate when there's 100 clauses that might affect it. So you might get a bit of an answer, but it's going to be a sort of slightly unwilling answer. It's going to be hedged, saying, I haven't looked at the whole thing. And then you'll get a bill for something you're vaguely unhappy with and didn't really give you the answer in the first place.
Yeah.
So that whole transaction, even if you've got a willing and able lawyer to help you, if you deal with a lawyer outside of the way that they deal with things and their skill, you're going to run into problems. So what I suggest is that you think about these things in advance. Say you're in the middle of a contract discussion and you want to know what this means. Even if it's the same day, drop an email to your lawyer. Say, this is what I want to discuss with you. Here is the document. Clause 42 is my problem. Can I have 10 minutes with you? Now, if you do that well in advance, like 3 days in advance, that's so much the better, because frankly, lawyers can't stop thinking. And if you hit them with a problem on Monday and you say you want a meeting on Thursday and it's half an hour, they're probably going to spend half an hour thinking about the problem in addition.
Yeah.
So you're going to get a better quality. The cake is baked for longer. It's been more prepared better. So put an agenda, put an email, put a time frame, give them an amount of time you need. You're going to get a much better result.
And that'll also reduce stress, because there's nothing worse than if you get an off-the-cuff answer to something that may not necessarily be the real answer. If you actually went through that particular process, you'll probably spend the next 24, 48, 72 hours until you actually get in front of a lawyer worrying about the potential outcome that may not necessarily be the outcome if you had gone through that particular process. So that's also important, because I think where the fear is, what you spoke about earlier, is the fear of the unknown. Yeah. And that's probably the biggest thing. So when we know what the outcomes are likely to be, then we can start to solve for it mentally. And that, I think, you know, certainty or known outcomes, better known outcomes, reduces that sort of stress level, from my experience. And I'm not sure whether you believe the same thing from your experience.
I do. And to use the example I just used, if you are going into contract discussions with someone, then if you just sort of in advance accept that it would be good to have someone by your side in that discussion, then if you'd emailed your lawyer, say on the Monday with the discussions on Thursday, then you might want to tell him, look, him or her, you might want to tell them that I might need to ring you in the course of this discussion or next week, but I need someone who's sort of can give me a quick answer. But if you've prepared the lawyer for that, they've looked at the contract, you can then get that quick answer because you prepared them. Whereas if you ring them in the middle of the discussion, you're going to get nothing.
That's right.
It's going to be hedged. So yeah, I think there's a process thing that can be dealt with there that will help people.
Yeah, it makes a huge amount of sense.
The next secret that I have, Matt, is secret number 4, and it is to talk the big picture with your lawyer. And this isn't just legal, but it's particularly applicable in legal. The example I give you is this. So for something that everyone would have thought about, people think, okay, I need a will. So what they do is they go to their lawyer and they say, I want to do a will.
Mm-hmm.
What's the price? Now, that's it's English. You can understand that. The lawyer can understand what your question is. But in fact, that's not actually what you really want to achieve. The will is the voice of what you want to achieve. It's the instrument under which it is achieved, but it's not actually what you want to achieve. And if you actually sit back and think about what it is you want to achieve, you really want to be thinking about that. You want answers to these questions. What happens if I die? I want to leave everything to my partner, but if they die, I want to leave everything to my kids.
Mm-hmm.
I want to make sure that my kids get the money, not an relationship partner of those kids. And then the question, which is, I'm not even sure what else I don't know, so ask me questions to help me. Now, if the two fact situations are, you go up to a lawyer and say, I want to do a will, or you say, look, I'm concerned about what happens if I don't have one, and I know I've got specific things I'm worried about, but I need to have a discussion about what I want to achieve first.
Mm.
And if you can do that, then suddenly the lawyer is on the same page as you. And the transaction is one that genuinely will meet your needs and not just be a piece of paper pulled off a system somewhere with your name put on it and left everywhere. If you don't think about asking those or collaborating on the bigger picture, good lawyers will open the picture up for you. But if you continue to say, no, I don't want to talk, I just want to do a will, you're going to get an instrument that probably won't meet the needs and will not even deal with things that you think it will deal with because you haven't spoken about it.
Yeah, that's a good point. And I think that, what we're always, one of the things that comes up about wills, for example, is that they're worried about it being contested at some particular point in time. And so, they've probably got that in the back of their mind when they're thinking about preparing a will, thinking, well, I need to make sure that, as you say, that the wealth passes to your spouse and then passes to your children. And they're worried that it might go beyond that, for example, to the children's spouses, or it might go to, one of the children's in dispute with the other one, and it might sort of end up in some sort of legal stoush at that particular point in time. So I suppose that's really what you're talking about. If you go there and say, look, this is what I want to have happen, but this is the potential issue that I've got to actually deal with because, the circumstances that we currently have at the moment. Would that be fair to say?
It's perfect, Matt. In fact, if you were to ask that, if you were to put your concern on what you want to achieve and the sort of doubt that you have to your lawyer, they really respond well. I don't think there's a lawyer on the planet who wouldn't be able to respond well to that and to talk to you about what it meant. The simple answer to that would be something like, you cannot remove the ability of the court to vary your will. And that just has to be accepted. And it's a hard thing to accept, but to know that in advance is important. But that lawyer will say to you things like, but what you can do is you can record what is happening to, say, benefit a family member on the way through, so that when a judge looks at this, if they do, they'll see that you've actually helped them and for reasons, and they've already received benefit on the way through. So there are things that can be done that you would learn about from that discussion. So I can't underestimate how important it is to talk about the big picture so that a suitable instrument can be found and that the contents of it will be appropriate for you.
And also, not only that, but the planning that can go on between times. So it might be that it's, yes, you need to actually do the instrument being the document, but there might be things that can occur prior to that document or, that event occurring that could give you greater protection if you actually did it early enough in that thought process.
Yes. The secret number 5 is, look, it isn't. I'll let you in on another secret, Matt. It's not actually a secret, but I think it is the most important thing that determines so much about what happens in the law, and that is the role of personality. Now, there are lots of personality sort of theories. There's probably 30, 40 of them that talk about, the different ways that people deal with stress, deal with problems, their ordinary personality, their personality under stress. And I'm not going to speak to exactly which one might be right or what elements are right. They're all correct in the sense that each one of us is different, and each one of us has things that they bring to the table and that they will apply to how they think about a legal transaction. So I'll just give you some ways that this plays out in the law. So the first thing I think in terms of personality is, does the personality of your lawyer suit you?
Mm-hmm.
And it's not rocket science to know that you have to get on with someone. And if you don't like someone, even if they're a great lawyer, don't stay with them. Go with someone that you actually enjoy being with, because that just makes it so much easier. And if there's any difficulties, you sort of understand each other in a way, personality wise already, or you appreciate that personality. It's not something anathema to you, and you can solve your problems more quickly. So if you don't like your personality of your lawyer, you're going to end up in some problem, I think, just because of that personality clash there.
It's actually a really good point, because I suppose because typically when you deal with a lawyer, it might be a little bit more transactional than relationship orientated. So compared to your accountant or something like that, or another professional advisor that you're speaking to on a more regular basis, because that's just the nature of what you're dealing with. Whereas legally, sometimes it can be transactional, and so therefore you're solving a problem. So therefore you're going to the expert to solve a problem. So therefore you're probably less inclined to think about the relationship compared to thinking about solving the problem. Whereas when you're going to see a wealth advisor or an accountant or something like that, you're also at front of mind, you want to get on with that person. So I think it's a really good point, and it's probably one that we discount because it could be seen as transactional. Now, the reality is that if you form a great relationship with a lawyer, they're there to call upon through, and because you're always going to need one throughout the life of your business, of being a business owner. So from that perspective, it's actually, you should be treated as if it's a relationship, and definitely one where you align yourself with them. And it could be aligned from a values perspective, it could be aligned from a you get along and you understand where each other's coming from, and there's a respect there and that sort of type thing. So I think it's a point that I can see why people might overlook that.
And yes, that's right, Matt. I think that people probably deal with lawyers a lot less, than they might with their accountants. However, for business people, I personally think that you should have like a number of people on speed dial that you can actually ring, and they'll take your call and that understand and get you. So that you've got accountants, you've got your IT people, you've got your own staff, hopefully your own family, and a lawyer. Yeah. And there might be other people as well, but it makes such a difference to be able to say, listen, going back to my previous point, I'm just wondering about this, should I be doing something? And to have someone who already understands you and knows you and that you like is so much better. So think about the relationship. I'd probably urge everyone to think of it, if they don't like their accountant, change it as well. No, seriously, because
absolutely.
it's better to work with people in your life that you like. So that's my first demonstration of where personality.
One of the other, just maybe smile a little bit, because one of the other analogies is don't pay people you hate. Whether they're staff members or whether they're professional service, because there's something, when you start to think about that, there's probably people that you do pay that you dislike, and you think, well, that's just madness.
Yeah, exactly. Okay, so just for the betterment of your life, be friends with your lawyer. So if you don't like your lawyer, change to someone you do like. Now, the next thing where it becomes important is, how will your lawyer and the opposing lawyer get on? Because if there is a dispute, how is that personality going to fit with someone else? Now, a good lawyer can, in some way, be a chameleon to be able to adapt to suit the lawyer on the other side. Because in fact, once someone goes to a lawyer, they generally trust their judgment. So what my job as your lawyer would be is to persuade, firstly, the lawyer on the other side that I am right and they are wrong, or that we should settle it at a place where they don't want to be.
Mm.
Now, if there's personality clashes there, it makes it so much harder. So the role of the personality of the lawyers is critical.
Mm.
The third point that comes in is how is your personality affecting the whole thing? So, for example, I have a matter at the moment where it's a large contract, many millions of dollars, and there's a question of the apportionment of risk under the contract. And the risks are that if there's something that goes wrong with it and there's losses on the other side because of something going wrong, what should be the amount of loss you're exposed to? Is it the total loss of the machine failing and all of their consequential losses, or should it be just the loss of the replacement of the machine, or should it be less than that?
Mm-hmm.
And that is something for which there can be legal answers, that there's higher risk and higher price, but ultimately a lot of it will come down to what you're comfortable with as a person. Now let's say that you're a person that says, I want no risk, so you'll only ever go to the loss of the cost of the machine that I supply that doesn't work. Every time there's a legal dispute, you're probably going to have that same attitude to advice from the lawyer. I want to be cautious and careful. So I'm not saying that has to change, but I'm saying it has to be recognized, because it's critical to know that you're actually influencing what happens as well. And these days, Matt, pretty much every dispute is referred to what's called mediation.
Mm.
And a mediation is something where people know all the facts, they've swapped their claims, and it's a persuasion game. Now, the way that you approach it in your personality is critical. The way that your lawyer approaches it is critical, and the way that the other side receives it through their lawyer is critical. And then, of course, the person who stands behind that client. So you have these 4 personalities at least, and there's probably more associated with it, because sometimes a company has other directors, sometimes they have shareholders, sometimes there's lenders who are involved. So I really think that personality is critical. I think that the better you understand yourself and how you think will be something that will bear on dealing with lawyers. Lawyers have types of personalities generally. They're generally introverted. They're generally conservative. They generally don't go high risk.
Mm-hmm.
I think one thing I saw this morning, Rudy Giuliani for President Trump, still President Trump, he's not a cautious lawyer anymore. And you can see how people do different things differently. If you were in a fight where Rudy Giuliani was opposed to you, you'd have to take into account that personality. That's at the extreme end, I think, of seeing how this works. The role of personality can also influence results. And I'll give you 2 examples, Matt, of where this has happened. There was a large piece of litigation. It involved a foreign company and a local client of mine. And there was many, many millions of dollars involved. And one of the things that had affected the other side was that they'd gone into this contract, they thought in good faith, and they thought they'd had the wrong thing done to them. And they wanted an apology from us so that they could take it to their shareholders and say, this person has apologized and here is the written apology and they did the wrong thing.
Mm-hmm.
And it was important in their culture that happened. Now, my guy does not have that type of personality where he says sorry.
Right.
So I valued that apology probably at around 6 million.
Wow.
So what was at stake in the mediation was what should happen with this thing. And ultimately, there was a deal done where this apology would be read to the court.
Mm-hmm.
It had no legal standing, didn't affect the case, but it was something that they wanted, and it meant the matter settled. Now that was, here it's derivative personality. It's the personality of the shareholders. who demand, and the directors who feel the same cultural thing, and the personality of my client who does not want to apologize because he's not a person who apologizes. So that can make a material difference. So that's one example.
Yep.
Another example is, I mean, it was a much smaller dispute, but it was a dispute about a pub and investors in the pub, quite well-off investors who had all contributed because it was a place where people had gone for social things and they got to know each other. So there'd been 6 or 7 people who had contributed a lot to do the pub up, and the owner of the pub did the wrong thing, and they lost their money. So they were suing for their money back. And I was acting for the pub. And what I identified after a while was that it wasn't so much the money for these people, it was how they felt about how they'd been treated. Because they could afford actually to lose the money. It would hurt a bit, but it wouldn't hurt that much. So I came up with a suggestion that with the one person that would not settle and wanted to take it to its conclusion, maybe we could name a corner of the pub after them. You know how they have the little plaques, and they say this is the person. So we agreed to pay money and put a plaque up, and that corner would forever be called that person's corner, and it settled.
Wow.
Now, there's nothing to do with the law there.
No.
There's nothing at all. I mean, it's within a legal environment, Matt, and there are legal claims and whatever, and you can be distracted by that. But that's not actually what was happening. What was actually happening was someone was hurt. Someone wanted to be recognised, and they were. And from that time on, because they still drank there, they could say that's their corner.
And what I've often find dealing with business owners constantly as well, and is around the term principle. You know, often people say it's the principle of the thing, and so therefore I'm going to fight because of that particular principle. It's not necessarily about the money. It's about, and probably that is similar to what you're talking about. That somebody was hurt, so there's an emotion associated with it, and that's what's driving it, not necessarily the the loss of money.
Well, it's interesting you use that example, Matt, because it's a perfect example of personality. If someone says it's the principle, then what they're valuing, what they're saying is that there is a right and a wrong here. And I don't doubt that there are rights and wrongs, and that you can say they're right and wrong. It just doesn't progress the matter.
No.
So if you are to do something on the basis of it's a matter of principle, and I have heard those words on many occasions, then I guess that gets back to another point I'm making, which is the big picture. The big picture here is, do you wish to spend a lot of money on pursuing a principle, even if you don't get back what you've lost? Is it that important to you? Now, if it is, no problem. But if it's not, that should be discussed up front, which I guess is that point of big picture for me.
I was talking to somebody the other day about this particular concept about fairness, principle, right, wrong. And, there's always going to be, at that layer of consciousness, people that are going to be unhappy. And typically everybody's unhappy when you're fighting at that particular level. But if you take it to a higher ground and a higher purpose, and you tap into that, then it seems like everybody gets a good result. In that situation, the aggrieved person feels like they got a good result because they got a corner of the pub named after themselves, and the pub owner was happy. So that was kind of taking it from the fairness and principle thing to a higher level. And I think that there's something in that if we can take it away from that sort of low levels of consciousness into a sort of a higher way of dealing with things, it seems to be a far better experience, where there's more likely chance that everybody walks away from it feeling okay about it.
Matt, you were mentioning before we came on air here that the big thing for business owners, one big thing is that's the worry about things going wrong. The 3 o'clock in the morning thing. And I guess if I want to tie all these points together in some sort of cohesive way, it would be really good to try and address that point to see how can we stop business owners worrying about something, even when there's doubt about it. So I'm dealing with a number of matters at the moment where there are there is litigation that's been filed or letters, heavy letters that have been written. And of course, when they're received, they have the desired effect, which is to make people not sleep, to worry, are they going to lose everything? You know, how much is it going to cost? When does it end? What do I have to do? And all of those things are, you know, they come one after the other and then they circle around. So you start at 3 o'clock thinking of one, you go through the circle, at 4 o'clock you start it again because there's no answer. So I think if we tie it together a bit here, if you approach a lawyer in a different way and say they're a team member, they cost a lot, I agree with that. A team member, what can I do to help them help me? How can I make it easy for them so that I get the best out of my lawyer? How can I start to think about things as well? And then come together, you're going to have a way of taking this worry away from you. Not completely, of course, because any dispute has unresolved elements to it when it starts, but you can actually sort of see where it's going to go. So let's use an example. It's 10 o'clock at night, process servers come to the door of the director. As a claim, $3 million. It's on the company for having supplied goods that weren't right. Yeah. So the first thing that is going to happen is they're going to worry all night. But let's move on to the useful thing, and that is, do you know a lawyer that you like and trust? If you do, that's great. If not, ring around, try and find someone. Have a discussion, send them the document, send them, I'd like to meet with you to talk about this. Can you give me some time? These are the points I'm concerned about. And this is where I come to the big picture. So that relationship that has now broken in some way because there's a suit for $3 million. Firstly, there are things that you can talk about with your lawyer. So firstly, are you going to have an ongoing relationship with that person, or is this the end of it? Because most commercial relationships go wrong on a transactional level. They don't have to end, but there might be something going to have to be resolved. So is it going to be ongoing? Secondly, is it a fight worth having? I mean, if you are in fact liable for $3 million and, you know, with a bit of work, you can sort of reach a deal about that, then maybe it should be settled quickly. So investigating it is important. You don't have to fight it. What about the disruption? You need to talk to your lawyer about how would I be disrupted? How many hours do I have to give you? Who will I have to involve in it? What will I have to produce? That's actually a very big drain. It's completely outside the legal system. It's not in court, but it does involve you. So discussions about that. And then the cost of the whole thing. And that's where it's difficult for lawyers to price these things, but there are, you know, people try, and you should try and work with your lawyer to work out how big is it, how long is it. The fact of it is that most things, Matt, will resolve at some point. And why do they resolve? They resolve on good readings of personality and of appropriate settlements in amount. So where you have this uncertainty, actually stop. Don't say to the lawyer, what's going to happen next, right? Because what happens next is entirely within your control. What you want to do is say to them, I want to sit down. Here's this thing that worries. These are all the things that worry me and scare me, legal costs included. Can we even give them 2 hours? Like, don't fetter the time. You know, the value of that initial discussion about ongoing relationships, total cost. Is this bet the farm? Is it something that's tactical? Are they genuinely after everything? Is it just a try on to get a letter settlement? Once you do that, then suddenly the big picture questions will start to be answered, and there'll start to be a bit of certainty about things. It's not the end of the world, I can tell you. Nothing. I've almost never seen anything that's the end of the world.
Which is comforting as well as a backstop to this whole conversation. But that's been fabulous, Brendan. Is there anything else that you wanted to add that comes to mind before we sort of close today's conversation?
No, other than lawyers are humans, which, you know, it's hard to believe sometimes in the way that they behave. Find a good one. There are good ones out there. It won't be cheap normally for good lawyers, but if you can get someone you work with, your life can be so much better. Just the ability to ring someone up and go, particularly in a business, this is focused on business people, just to go, even the question is you drive to work, quick email, just tell me about this. And a lawyer, I mean, as a lawyer who does that sort of stuff, I enjoy it. I enjoy knowing the backstory. I enjoy knowing what's happening, because when the question is asked about the problem, I've got it. I've got the backstory. I know how it's working.
No, I think it's fabulous advice. And look, it's been, once again, wonderful to speak to you. And I've always enjoyed that sort of pragmatic lens on how to deal with things. And that's why we've had such a great relationship over a number of years, because, that relationship has allowed me to sleep at night more than sometimes that I do. And
well, you're great at guiding business people, Matt, and giving them the big picture ideas on, not the day to day, but what they should do, big picture, how they should organise their lives to achieve a better business. And you have a great reputation for it. Oh,
thank you. But I just wanted to once again thank you for today and the information. I think it's been, it's very timely, especially with what's going on in the world. This is not going to go away. It's probably going to get bigger and uglier in a lot of regards. And just the tips on it, I think, like you said at the start, it's not rocket science, and we know these concepts a lot of the time, but we don't practice them. And this is a lot of the thing that, it's common sense, it's obvious, but it's bringing it from the back of the mind or the front of the mind sometimes, which allows us then to actually have a better outcome and a better experience. And that's really what these are, the 5 secrets that you're talking about today, and why I appreciate it, because it does put it in the front part of my lens. So thanks very much for your time again, Brendan. And
pleasure, Matt. Nice talking to you.
Okay, thanks.